And all of this can be included in a trust protected provision. This person has independent authority. Nobody can prevent him from acting on that authority, and nobody could require them to act on that authority. Traditionally, it's someone that has no dog in the fight. It's someone that has no interest in the trust. It's not a beneficiary. It's not a trustee. And it's usually someone that's close to the people establishing the trust. So if they suggest that a change might be made, then that independent person may make that change. But this gets you out of all of those problems that you see when you have a bad trust, or what the people creating it deem to be a bad trust. All right? It should be included in every irrevocable trust. There are clients that don't want to do it because they don't trust anybody. And so we've seen that before. There are certain limitations that we put on this. Some people want that when they die, they want this power to die with them. So the person who's the trust protector is eliminated once the person that created the trust dies. So there are modifications that can be made. The powers can be modified. They can't benefit themselves or their families or anyone that's not within that original pool of beneficiaries. But it gives us the added flexibility to make changes and correct things that we weren't sure we wanted to do at the beginning. Keith?
What provision do you use where the grantor is being named as the trustee?
Never.
Okay.
We never name the grantor as the trustee. Okay, when you have a beneficiary being named as trustee, we always include a secondary trustee called the distribution trustee. So no distributions are permitted to be made without the consent of this other party. The beneficiary as the trustee will have full investment authority over the trust. They don't have to consent with the distribution trustee for investments of the trust, but if any distributions are to be made, the secondary party must consent to the distributions in writing. And that's how we avoid, because from an asset protection standpoint, we don't want the beneficiary to be the sole trustee. Okay? Now, what happens if the client wasn't smart enough to come to us first and they have an irrevocable trust without a trust protector? And now the whole structure that they want has changed. They don't like what they have. And let's assume for the time being what's owned in that trust is a life insurance policy that can't be duplicated anywhere else. What we have had tremendous success in doing is creating another irrevocable trust with the same grantors, with the distribution that the grantors want, and then enter into a transaction where the first trust sells the policy to the second trust, either for cash or for a promissory note. Okay? Because both trusts are grantor trusts, there's no tax implications of it. There's also no transfer for value rule because there's between two grantor trusts and it's deemed it to be a transaction between a grantor and him or herself. The IRS has just approved this, by the way, through a revenue ruling that recently came out. Yes?
I got some literature in the mail the other day about the true value of life insurance, truly evaluating the policy, because the way contracts are structured today, there could be a very, very small value to them, but there could be a $10 million death benefit and the client's 90 years old. What's the true value?
Okay, that's a very good question. Now, once we've established this, how do we value the policy? I will tell you, our position is if the client is under 70 years old and there's no pending life or death health issues, we'll use the cash surrender value or the interpolated terminal reserve in a whole life contract to value that contract. If the client is over 70, or there is a real issue with the health, we'll get a third-party independent appraisal of that policy. And that policy, what they'll do is they'll analyze the policy, they'll look into the life settlement market, and they'll come back to us what the true value of that life insurance policy is. And we've had to do that on a number of occasions. Yes?
What about term insurance? Would it be the earned premium?
Term insurance, young, we use the unearned premium. So we usually do the transaction right before a premium is due, so it's of little significance. Okay? But when you have a client that's over 70 years old, you have to go to greater depths to value the policy, or else you're not going to get a true fail. And the IRS may come in and set aside the transaction. Yes? Sure.
Once the money goes into the old trust, after it's purchased out of the old trust, is there any time limit as to how long that money has to stay in that trust before it can be distributed out?
No, we actually had a transaction where the spouse was one of the beneficiaries of the old trust. So we just distributed out the money to the spouse immediately. Most of the time, you have it for the kids, and the money will either stay there, or we'll make distributions to the kids, or make another investment within the trust and to keep it going. All right? So again, the best way to avoid all of this is to have the trust protector in the trust so you can make those modifications, or the trust protector can independently make those modifications later on. All right. Should have a merger provision. Many of you have seen the trust that we prepare, and there are generally large number of trusts that come out of the trust that we prepare, and if we're preparing revocable trust and irrevocable trust, there could be 6 trusts for each beneficiary. What we want to be able to do is, after mom and dad die, be able to have, for administrative purposes, the smallest number of trusts that are required. So we have a merger provision contained in the trust that allow all like-kind trusts to be merged together, so you'll end up, in most cases, having 1 or 2 trusts for the benefit of each beneficiary, and you don't have all the administrative costs and the tax returns that are necessary amongst these multiple trusts. It's a fairly straightforward point. All right. Believe it or not, I always view this as estate planning 101. The trust document itself, if it's an irrevocable trust with the intention of having the assets outside of the grantor's estate, should never say that the trust authorizes the payment of the grantor's estate taxes. Sadly, I have encountered all too many trusts that say just that. If the trust says that, it means that all the assets in the trust are included in the grantor's estate. Because any document that says that you're allowed to meet the obligations of the grantor, which are estate taxes, liabilities, or anything else, is deemed to be